What was the most significant thing Donald Trump did as president? Love him or loathe him, Trump's Supreme Court appointments look like they might have been the most consequential thing he did in office. Of the 9 justices on the court, 1/3 of them, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, are Trump appointees. Trump's trio have decisively changed the balance of opinion on the court, and the implications of this only seem to grow. The Supreme Court recently ruled that affirmative action cannot be used as part of a university admissions process. Or, to be more precise, it ruled that the system used by Harvard University and the University of North Carolina does not comply with the principles of the Equal Protection Clause of the 14th Amendment or the protections of Title VI of the Civil Rights Act. For decades, universities have used race-based preferencing to rig their selection systems in favor of some racial groups and at the expense of others. Often, this has meant universities admitting more African American students with lower grades than they otherwise might have, and at the expense of Asian American students with higher grades. In the words of Justice Clarence Thomas, all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution. Progressive academics, hooked on woke ideology as an addict is to meth, may divisively look to circumvent the ruling. Regardless, an important victory has been won by those who believe that the way to end racial discrimination is to stop racially discriminating. A day later, the Supreme Court made another momentous decision when it ruled that President Biden's plan to cancel over $400 billion of student loan debt was also contrary to the Constitution. A few hours after that, the court ruled that a Christian website designer could not be compelled by state law in Colorado to articulate views that they did not themselves endorse. A year before, the court famously overturned Roe v. Wade, ruling that decisions about abortion should be left to each individual state. Maybe the court's most consequential ruling of all is one that has received the least attention. Last summer, the court ruled that the Environment Protection Agency did not have the power it presumed to have. For the first time since the New Deal, the legal assumptions that have allowed for the abuse of the administrative state are being challenged. Responding to the court's recent ruling on affirmative action, President Biden declared that this is not a normal court. He's right. The norm, since the 1950s, has been to have the Supreme Court adjudicate on the basis of what the judges would like the law to say. Today, we have a Supreme Court ruling on the basis of what the law actually says. So accustomed have we become after decades of judicial activism that might not feel normal, but it is what the founders intended. What the Supreme Court seems to have done is move away from judicial activism in favor of originalism, the idea that they should stay true to the original intentions of the founders when they drafted the Constitution. Perhaps that's one bias the Supreme Court should always have.